Hello students, welcome to this class, and in this class we are going to look at chapter number 9 about state succession in international law. So the purpose for this chapter is for you to understand the legal consequences and principles that apply when one state replaces another in responsibility for the international relations of a territory, ensuring continuity, clarity, and stability in international obligations during political transitions. So these are the objectives for this chapter. So, state succession arises where there is a definitive replacement of one state by another state. And in this case, the elements of statehood, that is territory, population, and recognized government, are completely taken over by another state or states. So, the state losing these elements of statehood, and that is the predecessor state, ceases to exist in international law, and its place in international law is taken over by the successor state or the states. So let us look at statehood, recognition, and succession. And this is based on UN General Assembly Resolution of 1970 on principles of international law, contemporary criteria, statehood. So let us look at the concept of UN membership. So UN Charter Article 41 says that membership in the United Nations is open to all other peace-loving states which accept the obligations contained in the present charter and in judgment of organization are able and willing to carry out these obligations. Also, uh, Article 42 uh, says the admission of any such state to membership in the UN will be affected by a decision of the General Assembly upon the recommendation of the Security Council. So let us look at any obligation to recognize. So there is no such obligation for states in international law, but there is obligation not recognized. So even if that entity satisfies all criteria, for example, in 1992, Yugoslav Arbitration Commission said that recognition is a discretionary act that other states may perform. Also, the US Department of State says that international law does not require a state to recognize another entity as a state. So, how do you withdraw from recognition? So, let us look at withdrawal of recognition. So, it is possible to withdraw a recognition because a unilateral act, particularly when we talk about de facto recognition of government, it is difficult regarding the de jure recognized states, but still possible. So, for example, in 1979, recognition of People's Republic of China and a kind of the recognition of Republic of China. Let us look at recognition of governments. So there has to be a change of government in an constitutional way, otherwise intervention into domestic affairs. So there have been different theories about recognition of governments, and we are going to look at these three theories. So the first is Toba Doctrine, whereby governments came to power and constitutionally should not be recognized until accepted by the inhabitants. So that's what that theory says. So there is another theory called Estrada Doctrine, which asks automatic recognition in all circumstances, otherwise against the right to self-determination. Also, there is another theory not to recognize a government, and since 1980s, UK policy no longer recognizes governments not to be perceived as approving undemocratic governments, and it is widely accepted state practice in in the world. So let us look at de facto and de jure recognition. So what you should know is that both of these are legal acts, and de facto recognition is different from implied recognition and acknowledgement. But all in all, uh, when we talk about de facto recognition, it refers to recognition of governments, not states. So let us look at extinction of statehood. So there are certain events that does not affect the international legal personality of a state. Firstly, occupation or illegal use of force against that state. That is, for example, in Kuwait. So also a change in name of flag or constitution, and these things are mostly happening in Africa. So also the change in government or internal upheavals. So for example, when the legal government is overthrown, the state does not cease to exist as an international legal personality. So that does not affect the international legal personality of a state. As we continue, so extinction of states also takes place in these three different ways. For example, merger, where states merge, for example, North and South Yemen. Also absorption, for example, the German unification, and lastly the dismemberment, for example, dissolution of Czechoslovakia in 1993, and it became extinct, and also the Soviet Union. So let us look at state acquisition of territory. So a territory in international law means any area of the Earth's surface which is the subject of sovereign rights and interests. So it is a definite part of the surface of the Earth where the state normally exercises jurisdiction over persons or things to the exclusion of another state. So the domain of a state therefore may be described as terrestrial, fluvial, or maritime, or aerial. So, so let us look at the traditional modes of acquiring a territory of a state, and these are through discovery, occupation, prescription, cession, annexation, assimilation, or conquest. So let us have a brief about some of the methods of acquiring a territory. So we have discovery. So discovery is the oldest method of acquiring title to territory. So up to the 18th century, discovery alone was enough to establish a legal title. Physical discovery or simple visual apprehension was sufficient enough to establish a right of sovereignty of a valid title. So discovery related to the title by discovery is the hinterland doctrine or the principle of continuity, and which says that if a state has made a settlement, it has a right to assume sovereignty over all adjacent vacant territory, which is necessary to the integrity and security of the settlement. So another method is occupation. So acquisition of territory by prescription means continued occupation over a long period of time by one state of territory and originally belonging to another state. So in that case, it becomes their territory. So lastly, let's look at conquest and annexation. So with the coming into force of the United Nations Charter, the acquisition of territory by conquest may no longer be legal under international law. To this day, however, some states still persist in acquiring territory by the use of force, such as the invasion of Kuwait by Iraq. So, I have added the reading materials for this chapter. In case you want to read more or make more research, you can go ahead and use these materials. That's all for now. Thank you.